This case ends exactly where the evidence, history, and law led it. The court imposes 5 years in prison, affirms deadly weapon and family violence findings, orders no contact with the victim, and recommends a therapeutic community, not as a reward, but as a final attempt at rehabilitation tied to parole eligibility, the judge explains, in plain language, why probation and parole failed before and why structure and treatment are now the only viable path forward. This ruling sends a clear message. Accountability doesn't disappear with age and repeated chances. Do not create entitlement to leniency. If you found this case as intense and thought-provoking as we did, make sure to hit that like button. Share your thoughts in the comments, and subscribe for more geo-drop-in courtroom breakdowns where law, psychology, and real consequences collide.
005111, and there's an affirmative finding of family violence. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, ma'am.
Any objections?
No.
State?
Not from the state.
No
Defense?
objection.
All right. Any witnesses from either side?
No.
Any witnesses?
None from the state.
All right, then, state. But Lucy, I believe you may be opposed. Just one moment.
I was silent, Your Honor.
All right, you're solid. All right, you may be excused.
Thank you, Your Honor.
All right. Counsel, I'll hear your argument.
Judge, Mr. White's had some issues in the past. He said it's different this time. He spent time in jail. It's helped him develop a new outlook. He told me he's going to follow your instructions. If you give him probation, he'll never be back here again. We like the recommendations, the probation, the outpatient treatment, weekly drug testing. He's had a drug problem. He needs to address that. Also, the 180-day jail sanction is a good idea. We're in agreement.
This is the most emotionally charged moment of the hearing. Mr. White speaks about his age, his mother's health, and the fear of losing her while incarcerated. And to be clear, those fears are real. Courts are not immune to emotion. But here's the hard truth. Judges cannot sentence based on potential regret alone. The judge's response cuts straight to the heart of accountability. If family mattered this much, why take actions that jeopardize freedom in the first place? This isn't cruelty. It's logic grounded in responsibility. Courts see this argument often. I'm different now. But change isn't measured by words spoken at sentencing. It's measured by behavior before arrest. That's why this moment feels so heavy. It's empathy colliding with reality. And it forces all of us to ask, should personal hardship reduce consequences when the public has already borne the risk?
The truth and nothing but the truth, so help you God.
I do.
All right, you can lower your hand, state your name for the record, please.
My name is Dean Lorenzo White.
All right, what did you want to say?
So I would say that I made a mistake in my life when I lost control.
All right, so here's the thing. Are these mistakes or are these choices?
No, it was really a mistake.
Why do you say it's a mistake?
Because I don't know, I just lost it at that moment.
Well, no.
I got really angry and stuff.
No, here's the thing. You picked up a hatchet, right?
I knew it was tomahawk.
Okay, you picked up 2 tomahawks. Did you think it was something else? Or did you know it was a tomahawk?
No, it was tomahawk. I just grabbed them and I wasn't thinking.
All right, so you grab 2 tomahawks. And according to this, it's with this Monique Gant,
Yes.
someone that you've used drugs with. I don't know why you all are still together because I read the PSI report and you have 2 children, younger children. You don't even know where they are because you were using drugs. She was using drugs. You didn't get your life together with CPS and your rights ended up being terminated.
What you just heard is a devastating chronological audit of a criminal career, and it's one of the most sobering parts of this case. The judge isn't piling on for drama. She's fulfilling her legal duty. Sentencing requires looking at patterns, not promises, and the pattern here is unmistakable. Probation failures, revoked supervision, escalating violence, repeated substance offenses, and prior prison sentences that didn't change behavior. Notice how carefully the judge distinguishes dismissed cases from convictions. She's not inflating the record, she's showing restraint. But even with that restraint, the conclusion is unavoidable. Every opportunity for community supervision has already been tried and failed. This is why judges say sentencing isn't about punishment alone, it's about risk management. And the question becomes painfully simple. How many chances are too many?
I went to my mom's house. That was my mom's house.
So why would you take try to take groceries from the vehicle?
I didn't take no groceries from no vehicle.
Well, I mean, she said you cut through her window. I'm assuming the window
Yeah,
was.
no, I picked up the little pipe thing, and it had plastic on the window, and I just like tore it open. and
Why?
everything. I was intoxicated too, so.
All right. Here's the thing, Mr. White. I don't think you'll be a good candidate for probation. And let me just tell you why. You've been on probation before. Then you have a theft case that you were convicted of. Then you have a criminal mischief that you were convicted of. Then you have an assault case that you were convicted of. This started in the 80s. And then you have another criminal mischief that you were convicted of. Then you have another assault case, they say dismissed for insufficient evidence. It's probably dismissed because the complainant didn't want to go forward with it. Then you had a possession of marijuana, and I realized it's marijuana, but you were placed on probation for that, and your probation was revoked. Then you had another assault, and now we're in the 2010s. You had another assault, and you were given probation, and your probation was revoked. Then now you have a violation of bond or protective order, which I'm assuming is related somehow to this incident.
This
Then
is
you
the turning point of the hearing. When Mr. White describes what happened as a mistake, the judge doesn't let that slide, and for good reason. In criminal law, words matter. A mistake implies accident. A choice implies intent. And once the judge walks him through the facts, picking up tomahawks, approaching the victim, making threats, that narrative of a momentary lapse completely collapses. This exchange is powerful because the judge is doing what probation officers, parole boards, and courts do every day, testing credibility. She's asking, did you lose control, or did you decide? And when the defendant admits intoxication, it doesn't excuse the behavior, it actually compounds the danger. This is where sympathy starts to drain out of the courtroom. So, let me ask you, at what point does intoxication stop being an explanation and start being an aggravating
really
factor?
dismiss missing witness. And now you're here before me. How old are you?
I'm going to be 62 years old.
All right. So I don't think you're a good candidate for probation.
Can I say something?
Sure.
See, I've changed my life. My mom got sick now. And I'm old too. And I don't know if I had that much time left in my life. But I really want to see my mom. She's in her 80s. If I go away, she will pass away. That's all I have in my life is my mom.
All right. So here's my question for you. And I'm not trying to be cruel, but you knew about your mom. Why would you do this, knowing about your mom?
Well, my mom just got sick recently since I've been locked up. This here started since I got locked up. She's been in the hospital in and out about 4 or 5 times. She had a minor heart attack.
Yeah.
I didn't think it was going to be like this.
Well, I mean, these are things we need to consider, right?
Yes, ma'am.
All right. This is what the court is going to do. The court is finding you guilty. There's an affirmative finding of deadly weapon, affirmative finding of family violence. The court will sentence you to 5 years in the prison, give you credit for any time served. This is to run concurrent with 2025 CC 005111. There's an affirmative finding of family violence, and there's to be no contact with Monique Gant, G-A-N-T. And the court will recommend the therapeutic community.
Let's pause here, because there's a lot packed into this opening exchange that viewers need to understand. Mr. White entered a knock-and-test plea, which means he's not admitting guilt outright, but he is accepting punishment as if he were guilty. The plea agreement caps his exposure at 6 years, includes a $1,500 fine, and critically carries affirmative findings of deadly weapon and family violence. Those findings are not symbolic. They trigger long-term legal consequences, including firearm bans and parole implications. Also note that this sentence is running concurrent with another case. That means the time overlaps instead of stacking, which already reflects a degree of leniency built into the agreement. When the judge confirms that both sides reviewed the PSI, the pre-sentence investigation that signals the court is about to rely heavily on Mr. White's criminal history, substance abuse record, and risk factors. This is the calm before the storm, and everything that follows flows directly from what's inside that
Mr.
report.
White, your history doesn't look good, right? And sometimes I I look at that, right? And I have to look at that because I have to consider everything. And so I'm looking at your history, and your offense is escalated. And then you have different issues where you are placed on probation, your probation gets revoked. You're given parole, you don't do well on parole. And I will tell you, I've done parole hearings before, and parole is so much easier than probation is, because parole is sort of, in a way, it's sort of like college. And this is the best way I can explain it. When you're in public school and you're not in college yet, everybody is telling you everything to do. This is your class for today. That's what probation does. When you get on parole, what they do is they don't tell you you need to do this, this, and this. They just give you a sheet of paper. You have your
This
freedom.
case may sound routine at first. Another plea, another sentencing, but don't be fooled. What unfolds in this courtroom is a brutal, methodical breakdown of a defendant's life choices, stretching back decades. We're talking about Glenn Lorenzo White, a man standing before the court on a no-contest plea with a deadly weapon, finding and family violence attached. That alone raises the stakes. But the real tension here comes from what the judge does next, peeling back layers of history, addiction, violence, and repeated failures under supervision. This is not a story about one bad day. This is about patterns, probation given, probation revoked, parole chances squandered, and now, a court deciding whether mercy is still an option or whether public safety has to come first. Listen closely to how the judge challenges the language of mistakes versus choices, because that distinction will define everything that follows. And as you watch this unfold, ask yourself, when does accountability finally outweigh sympathy?